Hello, and welcome to another edition of Ask the Professor, a crowd-supported, crowd-funded feature where we respond to your questions on politics, on political philosophy, economics, the course of history, cultural matters, all those things that concern us in our attempt to live a good life together.
All right, here's one from Bill, and he says, it's a bit long, so bear with me. I understand that under jury nullification, jurors may find a person not guilty, even if presented with irrefutable facts of guilt, if they believe that the law is wrong or unjust. It happened, for instance, with Henry Morgentaler's abortion trials. But that's his question. Are defense lawyers allowed to tell juries about it in Canada and the United States? And is it a good option for juries?
Yeah, jury nullification to me is one of those intriguing checks and balances, something that's extremely valuable but shouldn't be used very often. Because by and large, we make law through the consent of the governed. And it isn't right that 12 people should be able to defy Parliament. But jury nullification exists for a different reason. It exists because the political class can get out of touch with the people. It can pass laws that the public generally is not willing to see enforced. And the alternative to jury nullification was for jurors to return dishonest verdicts, when they would pretend they weren't convinced by the evidence, even though in fact they were. So jury nullification is an important way to make sure that the law arises from the consent of the governed, which in fact is how law arose in the English-speaking world. We tend to think of laws as coming from Parliament, since that's how they do arise in these days of excessive regulation, far too much law, and far too unstable law. But the English common law that was codified under Henry II, that's in the 12th century, that's before a Parliament has sat in England, was essentially determined by sending the royal justices around to inquire not only into the facts of a case, but to ask local people, what are the rules that you live under and have always lived under? And so it's very important that law should not lose its connection with the people. Now, in fact, in Canada, the courts very strongly discourage jury nullification, and they try not to have it brought to the attention of jurors. It seems like it's not done. And they do, as I say, have a point. When laws are passed by parliaments elected by the people, the majority will at some point does have to prevail, no matter how strong feelings are. But at the same time, there is some scope. If, for instance, you lived in a society in which there was legal slavery, and someone was before you being charged under a duly passed law with having aided a runaway slave, you might well say, I'm sorry, but I will not have a person punished for helping another human being to acquire their freedom. Even if the majority is against me, I'm not returning that verdict, and you may do as you will with me. But there are other cases. The English game laws were like this. England had fairly restrictive laws about hunting, but it was impossible to enforce them because juries just wouldn't convict. Now, in Canada, it's true that one place where jury nullification did come up with Henry Morgentaler. He was charged with running an abortion clinic back when that was illegal, and juries wouldn't convict him. Frankly, I think abortion should be against the law. Maybe it's impossible to enforce. I certainly prefer that this be in the hands of Parliament, but you know the exception that proves the rule. When you get a result you don't like, are you still willing to stand by the procedure? And the fact is, yes, you had people who were convinced at the time that the law against abortion was outdated, that it was prejudicial, it shouldn't be allowed to stand. Would I have those people defy their consciences in a courtroom? No, I would not. But at some point, you have to let a jury sit that does reflect the consensus of the majority, if that's what happens. You can't have the system grind to a halt unless the system is completely unjust. So yes, jury nullification does exist. It is a sort of nuclear option. It should not be used frequently, but it should be used when it needs to be, because it's one more check on a government that loses touch with the people and makes laws that do not reflect how the people do live or how they're willing to live.
It's a bit like civil disobedience.
Yeah, the difference is that jury nullification doesn't normally carry a penalty. You can get in situations where you might be found in contempt of court. I mean,
right. And that's a serious thing.
Yeah, when there's a constitutional tussle going on, the rules cannot specify all the procedures. To some extent, we're going to find out who's right here, and there will be consequences for being found to have been in the wrong. It gets unclear when the branches confront one another. But I remember there used to be a senator from Washington State, Steve Sims, who went around saying that there are 3 boxes that protect our liberty: the ballot box, the jury box, and the cartridge box. The last one being a ringing endorsement of the right Blackstone laid out, that in extremis, we are allowed to defend ourselves in the English-speaking world against tyrannical governments. The ballot box we all know, but we think, oh, if something's wrong, we should vote. But the jury box is important too, to ensure that the machinery of the state is not employed to grind down the average person. And frankly, I'd like to see a lot more jury trials. And I think one thing I'd like to see juries do is refuse to tolerate the endless delays that make the process the punishment. These days, you can be on trial for 4 or 5 years, even if you're completely innocent, and there's not much of a case against you. You can be bankrupted, you can be ruined, and have your time stolen from you. And that shouldn't be allowed. And I think maybe if juries were more involved, because what jury wants to sit for 5 years? You'd get serious pushback from the citizens. So let us not squeeze the jury out. Conclude with a quotation from Chesterton. Why not? He once said that with the best will in the world, the professionals in the legal system can only see the usual man in the usual place. But the 12 ordinary citizens in the jury box look at the defendant and think, it could be me. And they judge the facts and the procedures by thinking very, very plausibly, what if I suddenly found myself in that box going through all this? And that is not something we can surrender and keep our liberty, it seems to me.
All right. Thanks for that. Folks, if you would like to play along and ask your question of the professor, the URL on your screen will take you to a page where everything is explained. Thanks, and see you next time.